Hi, can everybody hear me okay?
You need this.
Okay. My name is Lisa Gonzalez Goetz, and I'm an expert in Social Security disability law. I have a long slide, and it goes through the entire process of Social Security and how we, as attorneys, represent clients and work hard to get the benefits, which in turn turns into Medicaid and Medicare benefits for allowance for claimants. I will start by saying the process is very confusing, very complicated, and to make it a little bit more current after lunch and waking everybody up, I'm going to talk quickly about the changes for 2017, okay? I pulled this out of the internet from the Social Security website, and there is a COLA adjustment for next year, and it's 0.3%, and it's not a lot, but it's the first time, I believe, in a few years that we're seeing any kind of increase. Then they also talk about tax rates. Here it talks about what is constituting work in terms of whether or not you can work and receive benefits, what is the maximum allowed monies to work for 2017 for an individual and for a couple, as well as Social Security, Supplemental Security Income, which is a welfare-based program. I am going to talk about mostly the two main programs for Social Security, which is SSI, which is Title 16, and Title 16 is a welfare-based program, and Title II disability, which is when you are entitled to receive benefits based on your work experience and how much money you've put into the system. So for Title II benefits, it's very individualized, and the amount of money that you receive has to do with how much money you put into the system. So really quick, with a show of hands, just to get a feel, how many people are currently receiving benefits? Okay, and how many people are in the process of applying for benefits? Okay, and how many people have heard me speak before? Okay, so not so bad. I didn't want to bore the people that had heard me before, and I want to make sure that I'm current. So nobody's talked about the election, and I know that it's a black hole when you go into the election. It's not anything that anybody really wants to talk about, regardless of what side you're on. But how the new election is going to impact the Social Security disability program affects each and every one of us here in this room. Nobody really knows. There's a lot of different theories on the case, and I would say, in my professional opinion, that assuming the economy does well, hopefully the new elected president will not look into the Social Security program to cut anything. So it's very economically based program. It's one of the first things that goes on the agenda when it's an election time, and anything that happens in Washington, D.C. directly affects and impacts our benefits. If the government doesn't work, we get furloughed. If we get furloughed, payments aren't made. Social Security or any federal workers do not work. They're considered non-essential, and monies don't get processed, cases don't get processed, delays are made, people don't get hired, people don't have overtime, and it affects. So right now, the hope is that in the next few months, the economy will continue to do well, and they're fighting other issues and leaving this program untouched. That's the hope. And I've heard a little bit of speculation with the VA and how that also interferes with new hirings. With respect to the VA program, I don't know as much about how it's going to impact as a Social Security program. I do both, but my bread and butter is Social Security. With regard to the new medical marijuana use in the state of Florida. So I put a little bit of information together. I know that this is a question that was asked for some doctors, and I often get this on my Q&A. So before I start with my slideshow, I wanted to talk about that mainly to make sure you guys are awake and listening. And also I got the keywords, which are pot, cannabis, reefer, Mary Jane, grass, or ganja, which I just heard. So the question is, does it affect the strength of my case if I want to file for Social Security benefits, or if I am on Social Security benefits and now I'm taking marijuana that is medically okay in the state which I live in? So the answer is, it's very complicated. There is no real answer. It's even though it's legal, it creates a lot of bias that may be looked at against you. So one of the things that I believe the courts are going to, and I've seen it in other states where marijuana is prescribed and legal, the way it affects is almost, well, we'll get there, because really and truly, the question is, if you need it, have it prescribed by your medical doctor, okay? And then I would, as an attorney, ask a doctor if that area of contention ever comes up with Social Security benefit and being able to receive benefits. My biggest area of contention would be whether or not it's medically necessary. So if you get a doctor that says, for example, the doctors were talking about spasticity, and they feel that it's necessary, then my suggestion would be, first, give me a prescription showing that you need it, and secondary, give me a letter from the doctor that prescribed it indicating how that's going to help you, how that's therapeutic, how it's medically necessary, to show that there's no materiality, that there's no overuse. Disability, and I'm going to go through that, is very subjective. It's based on the person that's evaluating you. Credibility plays a major, major role in what you say you feel, and it's really supported by medical records. So as you can imagine, you know, some people are diagnosed, as an example, some people are diagnosed with MS and they take the same medication, they're able to continue to work, their cognitive abilities are okay. In that case, that person is not disabled. Same person with the same medicine, same diagnosis, same lesions, same complaints, but they're able to work. It doesn't affect them. So the question is not necessarily the diagnosis that you have, but how the diagnosis affects your ability to work or maintain working. And then with the consumption of any drug or illegal substance, or even alcohol, which is legal, or drugs which are legal, the consumption of it, the side effects of it, how you obtain it, how that makes you feel, whether it helps or it doesn't help, whether you're socializing when you're doing it, also becomes a credible component of your case. So it can help, but it will most likely hurt. I have a list of the states. There are currently 28 states in the nation that have legal medical marijuana, and I practice in all the states. So as we go through the different states, because Social Security is a federal program, it's looked at federally, it still doesn't necessarily subscribe to the notion that it's okay to be taking medical marijuana. Now, if your doctor, who's your treating doctor, not a one-time doctor that gave you the script, but your actual doctor who's treating you for the MS, shows the necessity of it, then that will help bolster your credibility. So additional issues that come up when you are taking anything, whether it's prescribed or not prescribed, whether there are any kind of medications, the question becomes, how are you having the money to obtain it? Everybody seems to forget the component that even though Florida just passed a referendum and medical marijuana is legal, the amount of ounces and how much you can have has not been decided yet. And then the question becomes the amount of money that it costs. That can factor into a credibility factor with regard to disability. How are you obtaining the money? Could you use the money for other therapeutic reasons that may be more helpful for your improvement of your case, as opposed to something that's just looked at as a recreational drug, basically. So people's perception of it will affect. So that's a new thing in the legislation that we have. We also have more technological advances with Social Security claims. So for example, Stu said, I've traveled to different states. We're doing work nationwide, and we're doing it out of satellite video conference offices in my office. So we can have hearings in Alabama, Georgia, Tennessee, California, Honolulu. We have a case in Israel. We had some cases in American Samoa, and not all of them are televised, but almost all of them are. So technologically speaking, this is happening more often than not in an effort to process these claims, which are really, really delayed and backlogged. So for example, we have a lot of judges from Tennessee that are hearing cases that are in Miami-Dade County, and they're just plucking certain judges because of the fact that they have less work in certain offices, so they're trying to have them move the caseload, the backlog, to process. So these video technologies are really helping. Another thing is also, how much money would I receive if I got on disability, or what's actually happening to my case? Social Security at ssa.gov has a portal where you can go in and you can actually see your earnings and how much you've made your entire life. And instead of waiting for anything to come in the mail, you could be a little more proactive about your case. So the electronic era is really coming and hitting hard with something like the Social Security Administration. So this is an example of the definition of disability. In order to qualify for disability benefits, you have to show that you're not able to do any of your past relevant work or any job in the national economy whatsoever, and that your disability has lasted 1 year, is expected to last 1 year, or will result in death. So I've had people say to me, they have heard many times Social Security say you have to be out of work for 1 year in order to qualify. And that's not necessarily true. You have to be out of work for a year, but the process in and of itself takes 16 to 18 months generally. So even if you stopped working yesterday and you apply today, if you expect to be out of work for 12 months or more, file for disability. It's a long process, frustrating process. The bureaucracy is very, very slow. Don't wait, because you can always drop a claim if you do go back to work and you feel better. But every time you start a claim, you have to wait in line. These 18 months, 24 months, we have some cases that have gone to federal court and are taking about 5 years. So it's pretty important. The most important thing, and I think Dr. Steingo talked on this, is case preparation. So anybody who is on Social Security disability currently, as well as anybody who's looking to apply for Social Security disability or undergoing the application process right now, you must properly document your doctor visits. That is what shows when you need to provide medical records. And how do you document it? Is by going to your doctor, complaining, telling them how difficult it is to get out of bed some days, to sleep, to take care of your personal activities of daily living, to walk, to dress, to bathe, to socialize, to travel, to drive. Anything at all that may seem insignificant to you when you're at that doctor's office, record it before you go to your doctor, so that when you go to them, you're able to express this amount of detail, because those details go in your notes, and those notes will help. So if you're currently getting benefits, and let's say that the new administration decides to start reviewing more actively people that are already on benefits, and they say, Mr. Jones, we want to see your medical records, and we want to make sure that your MS has not stabilized and that you're not doing any kind of work and that you're okay. We need to see what doctor has been treating you. And you go, oh, I haven't gone to a doctor in 8 months. Or I'm going to the doctor and everything is fine. Or my medical records show that I've been on vacation. Those things are going to affect you. If you are on benefits immediately, they will affect you. If you're looking to get on benefits, okay, same thing. These things have to be documented. So it's important that you have a great doctor-patient relationship, And these are the most amazing doctors, and not everybody is blessed to have access to doctors like this. So if you have doctors, make sure that you have a nice rapport with them and that you're able to let them know how you feel and that they document it in their notes. And many, many times I go to hospitals and speak to different doctors, either psychiatrists, neurologists, GI doctors, and talk about the specific of note-taking. And in the electronic age, where there's no handwritten notes anymore, we actually tell the doctors, I'll sit with their forms and I'll show them the boxes to check. Did you sleep well at night? Did you eat? Do you prepare your meals? Do you drive? So everything gets well documented, because that is the kind of documentation that proves an existing disability and a continuing disability, right? So here it talks about proper preparation in order to get a fully favorable decision, the client's impairments regarding your work circumstances, and every attorney is different. So one of the issues and things that I hear very often is, I can't afford an attorney, or I'm going to use my neighbor who's an attorney. As an educational and informative seminar such as this, I want to inform and educate everybody. For Social Security purposes, it's a federal program. Every attorney gets paid only if you win, which it means contingency. So they won't take your case if they don't think they can win it. And they get paid based on the amount of retroactive monies that they get for you. And it's capped at $6,000. And that's true whether an attorney takes your case at the very initial level and does the first application, or at the reconsideration, or at the request for hearing, or at the hearing stage. The attorneys get paid the same amount. So lack of money should not be a reason for lack of representation in this area of law. Secondly, when you do get representation and you do ask an attorney whether or not they do Social Security disability, you want to, as anything, make sure you ask the follow-up question. How much of a percentage of your practice does Social Security disability? Is it 20%, 50%, 80%, 100%? Because this kind of law changes, and it has a lot to do with how prepared a person is, and it's a lot of paperwork. So you want to make sure that for the same amount of money, you get somebody who has a lot of experience. It's a very small area of practice. Most of the referrals that come in through doctors, social workers, or other attorneys. So don't go to a neighbor if they don't practice Social Security disability, and don't think that a lack of monetary funds in the up front is going to stop you from getting good representation, okay? This is an example of something that is called ERE. They're an electronic record. I don't know what else it stands for, but it's electronic record. And this is the kind of thing that you can go up and look and see what it looks like in a Social Security case. And it's broken down to different, jurisdictional requirements, earnings records, background information on all your appeals, and then all the medical records. So it's divided into different sections when you look at your case for Social Security purposes. The importance and the reason that I'm bringing this up to everybody is people don't understand that when you speak to the Social Security Administration, they take notes, they keep records of everything that went on, and those records show up in your case. And you may not remember things that you may have said to people, but they are showing up in your records, and they can help you or they can hurt you. So be very careful when you are applying, for those of you applying, and for anybody who is on disability benefits, if you are getting calls or letters from Social Security for an update and review of your medical records, they are reviewing to see if you have had any medical improvement. Be very aware of what you say and how you say it. And if you don't know how to answer their questions, you can always say, it's a bad day, can I call you back? That's all. You don't have to jump the gun and answer, because those answers get recorded, and eventually, maybe 12 months down the line or 18 months down the line, you're going to have to remember what you said on September 12th, 2014 to Social Security when they phoned you randomly at 3 o'clock in the afternoon. And that's really hard to do. This is a copy of what an earnings record looks like. Now these are electronically accessible to you under the SSA.gov. There's a lot of different types of wages that are received. So a person could be currently receiving benefits and working part-time. A person could be trying to apply for benefits and working part-time. A person can be not working, and this shows the last amount of dates that they worked. So in this example, you can see that in 89, 90, 91, there were no earnings really, and then something happened where they started again in 95, and they started earning some monies again. All the quarters of coverage get copied. So basically, for one type of benefit, which is SSI, you don't have to have these wages recorded. For Title II benefits, which is SSDC, you have to show that you've paid. The rule of thumb is 5 out of the last 10 years you paid FICA. So that's just, in a nutshell. We're going to do a Q&A which answers specific questions. Then there's also something called unsuccessful work activity, where you try to work but you're not able to. You can say to the judge, I tried but I wasn't able to continue working. Then there's also a trial work period, which says, okay, you're on benefits now. Try to work. We're going to give you 9 months to see how far you can work, how much you can do. And if you're not able to sustain that employment, then we won't count it against you. If you're able to, we won't count the earnings against you, but we'll take you off the books. So the trial work period is 9 months, and it's a very individual type of claimant. MS and compassionate allowance. Compassionate allowance was an initiative that was formed by DC, Washington, DC, trying to make sure that if you qualify under these precise medical components, you will find that you are entitled for automatic benefits. On the one hand, if you get a compassionate allowance, it's awesome because you get your benefits right away and you don't have to wait in the long bureaucratic line. On the other hand, if they give you a compassionate allowance and then they find that you didn't meet it, all the monies that you received, you technically owe back to the government. So you have to make sure that that compassionate allowance is supported by all the medical records and documentation from your doctors. And anybody with compassionate allowance can get the help from either their therapist, social worker, doctor, attorney, and make sure that you have good advice. It does help, and it just moves you into the front of the line when it comes to Social Security. It is not a separate program. This is a list of all the categories that fall under compassionate allowance. It is for the most severe, most dire, most critical cases. I will tell you that in August of last year, I had 5 people die on me. They were compassionate allowance cases, and we tried everything and anything to get them through as compassionate allowances, and it was impossible. On the other hand, we had about 18 or 19 compassionate allowances that were awarded. So it is something that you really need a huge amount of advocacy supporting you. Okay, these are some of the compassionate allowances. You can always email me, I can give them to you, or you can look online. It's under the CAL initiative, 1L, C-A-L initiative. And this talks a little bit more about it. It talks about, for MS, the qualifying candidates for compassionate allowance. You really need documentation from your medical doctor showing that the MS is aggressive, that you fall into certain categories, that your MRIs are showing specific things, that your activities of daily living are showing specific things, that all the range of motion that they've done, neuropsych testing, and all of these things support a compassionate allowance. These are the application processes. You have the initial application. Statistically, I think something like 88% of the cases get denied initially, but those are state figures, so every state is a little differently. Nationwide is different. You apply at an initial level saying, I can't work. I won't be able to work for 12 months or more. I'm very sick. chances are you'll get denied. You have to apply an appeal with a reconsideration. You have 60 days to appeal. If you don't use it within those 60 days, you go back to an initial. So use that time wisely. If you get denied at reconsideration has a little tougher views. They develop the case a little better. They send you out to doctors, supposedly, depending on the region that you're in, to evaluate you. And if at a reconsideration case you don't win, then you go into request for hearing, where you're asking for a judge to listen to you and listen to your case. So most cases go into a request for hearing. Many attorneys, and I know because they're my colleagues, won't take a case until it's at the request for hearing level, because they don't make any more money. We're capped at $6,000, whether they take it at the end or at the beginning of a case. It's very it's a very personal decision. So for us and our practice, we take cases at initial, because I like to document a case from the beginning. I like to make sure that everything is flowing, that all documentation is together. And many times we can win at the initial or at the reconsideration level if we have that. If you go into a hearing, and a hearing is credibility, right now there's a lot of wait. The Fort Lauderdale office in Broward has a 365-day wait from the request for hearing to a hearing, so that's a year, while other offices are able to process their claims in maybe 100 days. So it's different nationwide, which is why I indicated that in Tennessee, they're pulling out some judges to listen to cases in Miami, and then they're doing the same with some cases in Broward County at the commercial office, commercial avenue office, trying to process cases at the hearing level. So there is a big move to try to process it a little quicker. You have to prove disability medically, and also you have to show that your area of functioning is precluding you from doing any kind of work. So there's a lot of ratings with disability. There's a lot of 20%, 50%, 70%. With Social Security disability, it's either 0 or 100. You either can work or you can't. So that's what makes it so very difficult for people, especially MS patients, to be able to apply for disability, because the profile is of a person with MS who's been suffering for a long time before they get diagnosed, and then they don't want to stop working, they want to continue. The problem is that when you start deteriorating, it's a permanent deterioration. So if you're able to get, and for the people that I know that have gotten MS for before they decompensate and deteriorate so much, then they have a longer ability to maintain stability. They don't decompensate because they have one less factor of stress taken away. Many patients with MS still work. They do part-time work. They still qualify, or they do some volunteer work. They will qualify. So my advice to predominantly MS is do not wait till the level of progression gets to such degree that you're not able to do it, because the stress and added fatigue of the stress is going to turn into permanent damage to yourself, and you don't need to go through that. That's me, and that's it for the slideshow. So I am open to any Q&As for anybody who has any specific questions. Any questions?
Anybody have any questions out there? Okay, Craig. Oh, Maria's there too.
Hi, thank you. This is the first time I've heard your talk. It's very nice.
Thank you.
So I am receiving Social Security. I was one of the fortunate ones that after denied the first time, and the second time I got it fairly quickly. My confusion is on, after I had stopped working, I got a little better, like you said, because part of the stress was taken away, and people keep telling me that that's why I got a little better. And part of me wants to go back to work because I got better. But that's the confusing part. And you were talking about how we can't be better, really, as far as medically records. On our medical records, we really can't be better. I'm a little confused by that.
Okay, so there's a process that's called a continuing review. So like anything is when you're receiving benefits on anything, they have the right to ask you to see if there's medical improvement. The government has the right to take your benefits away if they find that you have improved medically. Those cases become issues as to whether or not maybe you have improved by becoming stable, but it doesn't mean that you're able to work at the severity of being able to work. So these are cases that, depending on what happens right now with Washington and the administration, I would say that the first thing they're going to look at, if they look at the Social Security program, which I don't think they're going to right now, but if they were to, I think one of the biggest amount of resources that they're spending is reviewing the people that are currently on benefits, seeing whether or not they have improved, seeing whether or not that improvement means that they're able to substantially perform any gainful work employment. So continuing with your doctors, showing that improvement means stability as opposed to improvement is very, very big. Does that answer the question? It's not the answer we want, but it just means because they're the ones paying, they have a right to always check up and make sure that we continue to be on the path of treatment and that we continue to need these benefits. So the law says on a continuation of review, if you have improved, they have to go ahead and do the entire system again and see whether or not there's any work out there that you can do. If you have not improved, they cannot take your benefits away. So a lot of it depends on under what criteria they gave you the benefits for at the reconsideration level for you, for example. What medical listing did they find that you meet, and then they question whether or not there was improvement. So I argue all the time in these cases that when somebody goes to doctors on a continuous basis and somebody's getting treatment, and somebody's getting the treatment they need and the medications that they need, they have stabilized. They have just stopped from decompensating, but it doesn't mean that they've improved to the level where they can perform substantial gainful work employment.
So while on SSDI, is there any amount of income that can be made, or is there a cap, or can none be made?
Yes, okay, so this is where I call it the red flag. The government wants you to go back to work, and they say, yes, there is income that you can make. In the figures on my first slide, I'm going to try to see if I can pull that back up. I'm not sure, but if I can, I will. I'll get it. I'll get it for you guys, or you can email me, or you can look up. So there is an amount. It's about $1,100 a month that you can earn and still be able to receive disability benefits. And if you've heard me in any other program, or today, if it's the first time, I would completely advise you to be very, very careful. Once you start working and you start paying money into the system, it's red flagged, and they will look to see whether or not you are keeping those numbers low purposefully so that you can double dip. So I work 20 hours a week. That's all I can do. I'm not able to work 40 hours a week. 20 hours a week is the most I can work. How much money am I making every month? $700. I'm opening the door for them to say, why are you not working 25 or 30 hours or even 40 hours? Oh, they're not giving me those hours. Oh, then you're not disabled. Because if somebody gave you those hours and you could do more work, then you're not disabled. So anytime you start putting money into the system, my suggestion would be start very low. Keep it at about $300, $400, $500 a month. Make sure that your doctor knows you're working, but you're not able to do more work, and that should make it clear. But anytime you hit higher figures, then the question becomes if you're keeping it artificially low. And in people that are across the nation in different areas, Social Security is a nationwide program. So many times in places like we had spoken in Albuquerque, New Mexico, they'll say there's only 35 jobs in my area that I could probably perform, and there's no work here. The government says, too bad, it's a nationwide program. So if there's 35,000 jobs nationwide and you need to move, then that's fair game.
Next question, right rear.
Thank you for taking our questions today and your talk. My question to you is, if you go into disability, do you lose your retirement benefits, or how that does affect your retirement benefits at one point?
Okay, so there are many different type of retirement benefits. Are you talking about your Social Security benefits, retirement benefits? Yes. Okay. So in essence, what you're doing is you are retiring early because of a disability. So if at any time prior to age 65, you become disabled, you would collect 100% of your disability, of your retirement based on your disability. Okay? So if you are 62 and you're collecting 80% and you're sick, you should apply for benefits because you can collect the difference of the 20%. It doesn't actually affect, it gives you the amount of money you would receive at 65.
Next question. Where are we? Well, we have one over here, but I need somebody to get over to this side of the room, or you could ask the question, I'll just repeat it. I said, whoever's next to ask a question. Olga.
Lisa, I'm on SSI right now, but I'm only 53 years old.
Put the mic in front of her, please.
So when I get to retirement age, will I be getting my full retirement benefits? I'm on SSI right now, and I'm at 53.
So you're 53 years old and you're currently receiving SSI benefits. And the question is, when you turn 62, 65 years old, could you receive what you paid into the system? The answer is yes. The issue that this particular lady is talking about is that sometimes we pay money into the system, but we've expired our right to receive those monies. So if we've worked and we haven't used the rule of thumb 5 out of the last 10 years, if we haven't worked 5 out of the last 10 years, and I last worked in 2009 or in 2010 or 2012 because I'm not able to get benefits, I don't qualify anymore under the earnings that I had. Even if I'm an attorney and even if I stand to get $2,000 a month on disability, I would be entitled to 0, right? Because my benefits, my quarters of coverage expired. So in this case, the question is, do you fall under the other program, which is SSI? And this lady's receiving monies out of SSI, which is not just disabled, but also resources and finances bring you to that. The government will automatically flip you to another program.
Hi, thank you again for being here. I don't even know if you can answer this question, but does Social Security help with adaptive measures for your home? Like to put ramps and items like that, or helping in the home to open up doorways? No, right?
Okay, I don't know about that. I do know that those are the kind of questions that come with the Medicare that you do get, and the insurance that you're receiving should be the ones to answer. Okay?
I receive SSI now, and my wife is going to retire at the end of the year. Does that make any difference on her, whatever she's going to get, because I do receive SSI?
It makes a difference for you, because if she makes a certain amount of money on retirement, she may disqualify you if what you're getting is Title 16 SSI.
For the gainful employment, how do they consider that? Because say you're making $50,000 a year, you're doing a job that requires a lot of thought. Suddenly you have cognition problems, you can't do that job. Maybe you can be a greeter at Walmart or a cashier 20 or 30 hours a week. How do they decide that you can or can't work because you've just lost $30,000 a year in income?
Okay, so the question is whether or not your income substantially deteriorates or declines because of your cognition problems, whether or not they consider that substantial gainful work activity. Okay, that is a huge, very vast question that requires a lot of different points. I will say that they consider it with vocationally relevant factors. So based on your age, education, past relevant work experience, they determine whether or not you can can return to the work you did, or whether you have the skills or transferability of skills to do any other kind of work. Okay, work is defined based on how much money you bring in, not on the amount of money that you're used to receiving. So for example, I had a doctor who had Parkinson's. He was a surgeon. He was no longer able to perform surgeries because of the problems that he had with keeping still during surgery. They found Social Security was alleging that he was not able to return to his past work, but he could teach, or he could sell surgical tools. And we had to show that he couldn't do any of that. Okay? So it's not a question as to whether or not you can adapt to the new lifestyle and the new monies that you don't have anymore. The question really is, if based on the work that you did and your past work, your skills that you did, your age, your education, whether or not vocational factors transfer. And that is a huge area of law which we argue daily against vocational experts and doctors, and we take that to federal court all the time.
We have time only for one more question. I'm going to go to this side of the room, please.
For SSDI, I wasn't aware of this, that you show $1,170 a month income. So if someone has a rental property and they're making $1,200 a month before their deductions of taxes, insurance, and everything else, does that disqualify them for the SSDI?
You're qualified before you even use that scenario, because for SSI, it's an indigent type program. So you have to show that you have total resources less than $2,000, excluding a car and a home. You have to show that you're at the marginal level, and that's determined yearly, and I think it's $779. So what you were looking at were the thresholds for SSDI, Social Security disability income under Title II.
Thank you, Lisa. Thank you, thank you. So for anybody that might still have questions for Lisa or any of the previous presenters, you can send an email to me or info@msviewsandnews.org, and we will get it to one of our presenters. Please make sure that you tell me that it's okay that they can contact you directly, because I'm not going to be in the middle. All right, but I'm going to have the person that you want to speak to, have them answer you directly, okay? So one more thing, quickly. Jeff is just coming up to give a quick 30 seconds of a little shakedown warm-up, and then he's finished, and then we're going to have our final speaker of the day. Lisa, sorry. Oops, I forgot. We got one more thing, one more photo opportunity. Photo up. Who's taking the photo here? I need a quick photo here. Hold your plaque, please. Thank you.
Not your arm.
There you go. Everybody say thank you, Lisa. Thank you, Lisa.